really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
Filing my cases shouldn't be that difficult. There's got to be an easier way.
Nothing frustrates me more than having to wait for my attorney to call me back. I need them now.
What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
And welcome back to the Zona Law podcast. I am Mark Zinman, one of the attorneys with Zona Law.
I'm Scott Baluha, another one of the attorneys at Zona Law. Today is August 14th, 2020, and we're here to give you some more updates about the status of executive orders, gyms, as well as different things that are going on in the landlord-tenant world.
Sounds good. And while I probably shouldn't do this on a podcast, I will acknowledge this is now the third time we've started this podcast, and I've butchered this twice before.
I wasn't going to say anything.
So if I stutter or mess up, just go with it and just accept that as good legal service for everybody out there. So we are going to hit a couple different topics, discuss them quick, just so you guys get your information and move on from there. So first, we're going to talk about the executive orders, both on a state level as well as what President Trump came out and ordered. The fact that the property owners have gone and sued over the executive order here in the state of Arizona. And finally, the question that we're getting a lot from managers is what to do with gyms. We know there's executive orders. We know there's lawsuits filed by Mountainside and other gyms as well. How does that affect property managers? So let's tee it off real quick. Kind of the high level stuff, of course, is across the country. President Trump came out with an alleged order on evictions.
Yes.
What do we need to know? Give me the one bullet point. What do managers need to know?
The very short is that it has no practical application whatsoever on your day-to-day operations. It was a lot of words, a lot of memorandums, but not a lot of substance to it. Essentially, it left it up to the Department of Health and Human Services to try to create guidance to help assist renters and landlords, but there were no real orders that came out of it.
Yeah, and that's how I took it. It's partly a political move, partly a statement saying what the president wants, but it didn't actually order, hey, you have until this long for a moratorium. It just gave some guidance. So the next thing is where we have actual orders is Governor Ducey's order delaying writs after an eviction judgment. So we had the order that's going way back to March that was supposed to expire in July. Governor Ducey then extended it all the way through October 31st. But critical for here, everybody, is that he added two new requirements effective August 21st, which is next week. So how did we get here in terms of what was the old requirements and what are the two new requirements?
Well, the old requirements had a requirement for the tenants in those circumstances that they've been directly affected by COVID-19 to show that they have been affected and what documentation they have to give to a landlord in order to support that. So the general practice is that if a judgment is entered against a tenant in these circumstances, a writ of restitution gets served. When the constable comes out to their door, they're allowed to show certain documentation to stop from being removed from their home. To show that you're directly affected by COVID-19 doesn't mean that you have to show that you've been diagnosed with it, simply that you've lost income, you've lost your job, you're staying home with school-aged children. That was
pre-existing conditions that make you more susceptible to getting it.
Exactly.
Basically, it's the financial or the medical. It's almost anything.
Right.
What are the new two requirements on top of that?
So on top of that, there's now a requirement that the tenant reach out to the landlord and to try to work out a payment plan. That's the first one. And then the second one is that they have to apply for rental assistance. The biggest problem with both of those two is what's the practical application of that? How does that actually result in additional requirements for a tenant? And the bar is pretty low here.
Yeah, and that's absolutely how we're advising clients on that, because we're getting requests saying, oh, well, the tenant offered a payment plan, but it's ridiculous, it's not enough, or they've come up with some money, but it's not enough. Well, unfortunately, the governor's executive order is incredibly broad and is a very low standard. All the language says is they have to request a payment plan. Well, a tenant contacting a manager saying, hey, I've got $15 a month, is that good enough for you? That's requesting a payment plan. The second one, of course, is they have to apply for rental assistance, which they can do online. They can fill it out, take a screenshot, and send that to the manager. It doesn't require that they follow up with that rental assistance, which is the hardest part for landlords right now. As many economic impacts that there's been because of COVID on the residents, it's the same thing on landlords. And that's what we're trying to fix here. And I know that's what property owners are trying to fix, obviously, with a lawsuit.
And one of the simple ways to try to resolve this is once you have a landlord that's gotten an eviction judgment, you go down to the Department of Housing, you say, look, I obviously had a rental agreement here. This is the amount of money that I'm due. This cuts out the middleman. It makes the red tape a lot easier to get through, and provides the assistance directly to the tenants through the landlord. But those suggestions weren't very well taken.
No, we did pitch that, which I thought was the greatest idea, is literally if you get an eviction judgment against somebody, take that, get the rental assistance, take the judgment itself to the housing department here, and then have them release funds direct to the landlord. The benefit is tenant gets to stay, landlord gets to pay their mortgage, and everyone's happy.
And as part of that agreement in taking the money as a landlord, you'd vacate the judgment, which also ends up saving the tenant in that circumstance from having negative credit implications associated with the judgment. So it's a win for everyone, but it doesn't seem like that's a good idea.
Maybe that's why we're attorneys and we're not in politics or in the government. Maybe we just, I don't know. It baffles my mind, but we try and come up with these suggestions. So let's jump now. This week, property owners, different associations, the AMA, the MHCA, filed suit against the governor over the executive order.
Right.
I cannot stress this enough, and this is what people have to realize. It's been actually well reported about this issue. This is not about filing evictions. As much as people want to say, oh, it's a lawsuit over evictions, it's really not. This is a lawsuit to protect property owners' rights and to make sure, like we mentioned before, residents are negatively impacted by COVID financially. Landlords are as well. And while Governor Ducey's executive order allows residents to stay, it doesn't cure the financial problems that landlords are in, right?
Correct. At a recent press conference that Governor Ducey had yesterday, August 13th, the statement that he ended up giving out to the press and to everyone in response to this lawsuit being filed was get in line. Well, that's a really negative way to look at this process and the real life impact that it has on the tenants that are impacted. Governor Ducey repeated several times about the amount of money that's out there and that's available. That's great. That money might be out there and available, but the data that's being sent out by the Department of Housing shows that there's, as of August 10th, about 21,000 applications that are out there, and only 1,400 since the end of March have been processed and money delivered to those tenants to protect them and to keep them in their home. That's an inefficient administration of these funds. And
it's baffling to me.
Right. It's creating more stress. If you're in that application process, if you have to jump through all of these hoops and you're a renter, I'm sure that that's increasing your stress, making it more likely that, you're going to have more negative effects as a result of this.
Yeah, and managers don't want to do the evictions. That's the important thing for people to realize. Whether you're in a single-family home and this is your only property, or you manage a multifamily property, evictions cost the landlord money. Vacancy costs money. The problem is, worse than all of that, is having somebody live in your property that's not paying. And so when we have this financial crisis that we're in right now, it's a public crisis. And the public should come in and fund whatever is needed. We have all of these different options of the way that's done. But if that money's not being released to landlords, then they're effectively taking on that public issue as a private landlord. And that's the problem.
And now if you're in the shoes of the landlord, you're now forced to house people in contravention of the contract that you ended up entering into with the tenant. So it puts everybody at a disadvantage. But ultimately, the renters are the ones that suffer from the poor administration of these programs.
Yeah. And so we won't try to bore you guys too much. I mean, look, Scott and I love the legal side of things. I can tell you there's constitutional issues in that case. There's a contract clause case that the government shouldn't interfere with contract. We won't bore you too much. We'll keep you updated, though. That case has actually been filed directly in the Supreme Court. So you have two issues. They have to accept jurisdiction because they don't have to hear the cases if they don't want to. And then once they accept jurisdiction, if they do, then they get to the case on the merits. What's interesting, of course, is that there's cases right now by gyms, there's cases by bars.
Right, by water parks.
And then, of course, now property owners are in that as well. So it's a huge issue going across the state, and we're really going to keep you guys updated to see how that is addressed in the Supreme Court.
And the landlords that are a party to this special action are the ones that have been directly impacted in that there was a judgment that was entered, there was a writ of restitution that was requested, and then a motion to compel was filed in order to execute on the writ of restitution, and they were denied by the courts. And that's kind of the general gist of how all of this came about.
Yeah, and we have clients that are owed over $10,000 in rent, and now they can't get their resident out. I mean, just think on a personal level where that would put you as an individual. If you owned a property, maybe that was your retirement, maybe that was just an extra investment. How does that impact you to lose $5 digits. I mean, that's a lot of money to everybody. And so that's what this is. But we did mention the water parks, and so we should also get into the executive order addressing gyms right now. So there's been a lot of lawsuits over the executive order closing down gyms. Every time that there's a news article, we seem to get questions from clients, which is actually good. We like that, so that makes sure that they're being proactive to know where they are. But what's the status right now with gyms?
Well, before we get into what the current status is, how did we arrive here, and what's the specific impact on multifamily housing as well as the manufactured housing communities? Because the guidance that came out with regards to closing gyms was so vague, we didn't know specifically if it applied to the multi-housing association, that we took the conservative approach and we said, well, as part of this order, we should close down. Last week, there was an order that came out of the Superior Court that said, well, the gyms, the Department of Health, Arizona Department of Health, has to come out with guidelines about reopening those gyms. What are the necessary components so that everybody knows how it is that they decide whether or not to reopen? And that's where we are now.
Yeah, so if you remember, everybody addressed, Governor's executive order a while ago addressed pools and gyms in the same provision. And it basically just said, here's the rule across the board. We're closing all gyms. And then for pools, we're closing all pools except when they're on private property, such as apartments. So for us, for our clients, it was easy. Okay, pools can be open, provided there's social distancing. But the gym one didn't have that exception, so it appears to close all gyms. Now they're working towards creating the opening, and then clients obviously ask us how to do it. So first, the new rules are the county has to be at a percentage for positive testing below 10% before they can even apply to reopen. Once they hit those county numbers, which Maricopa's not at yet, I don't think Pima's at there either, after that, the gyms have to follow certain rules set forth by the government, including pause, cleaning after every single use. Now think about that in a multifamily property, how that's going to work. And then number 3, they have to also sign an attestation to say that they're going to ongoingly comply with these rules.
And one of the more stressful components of this is it's a tiered response. It's that, yes, once it's below a 10% positivity rate, you can open up the gym area, but it's only at 25%. Once you get below 5%, then you can do 50%. And then when it's below 3%, then you can open up at 100%. So on a multi-housing level, how are you also going to enforce the 25% in addition to all the other requirements?
I mean, it is so hard for property managers, and that's why we're reaching out to the governor. Give us the direction. Just say, look, an apartment community that has a gym is different than a gym such as Mountainside, where that is their core business. I mean, realistically, in an apartment community, the gym is an ancillary service. Whether it's open or not is not material to providing a rental property. And I think what Governor Ducey addressed actually for the water parks is really guiding here, because a reporter in the press conference yesterday asked about that, is saying, well, how come water parks are closed, but like in a hotel where they have slides and other things, those are open? And the governor basically said, well, it's different in a hotel. They're providing a transient place to stay, and the swimming and everything else is really ancillary. So that's not their core business, whereas a water park it is. And that's how I look at apartments and gyms, right?
Right. It would be more efficient to create that specific guidance that says that those multifamily housing communities are exempted from it, but we haven't gotten that clarity, and without that clarity, we can't take on the responsibility of saying, yes, you can open it up and treat it as though it's a hotel or one of those ancillary services, but we can't take that position.
Yeah, it's not in there yet. Until we get clear direction from the governor saying this does not apply to you, the presumption is if you have a gym, you have to follow those onerous rules. I just can't imagine a manager every time somebody goes to use the elliptical, they run from the office to the gym, wipe it down, spray it down, and then run back and continue their day-to-day jobs. So if we hear anything, we will absolutely come back to the podcast and let you guys know. We've obviously sent out, in addition to the podcast, countless newsletters updating everybody as well. Anything else for you for the day?
I think that's everything until the next time that we have these updates. And they're coming pretty fast and furious. So we just encourage everybody to stay on top of, keeping up with the newsletters, watching the updates and the podcasts, because what we're saying today might not be true a week from now.
Again, it's always a pleasure to be here with you, Scott. And we'll see you next time on the Zona Law podcast.